Welcome to Day 4, Session 2 of the Virtual School on IP. The topic for this session is points to consider while replying to objections of trademark registry. Our speaker for this session is Mr. Mathews Verghese, who is a managing associate with Intel Advocare and has extensive work experience of around 12 years in trademark, copyright and design prosecution, and handles both Indian and international clients. His practice focuses on advising on all aspects of trademarks, copyright, and design prosecution, including clearance searches, application, strategic development, and management of worldwide trademark, copyright, and design portfolios. With prior experience in handling matters in the contentious and the non-contentious field, his experience and focus is to assist clients with commercial and holistic solutions to the numerous intellectual property problems. His experience has also led him to handle clients across various industries such as apparel, luxury, pharmaceuticals, FMCG, technology, and retail. Mr. Mathews regularly appears before the 5 trademark registries in India and has in-depth knowledge as to its working. Pursuant to completing his law from a prestigious law school in India, Mr. Mathews went on to also complete his master's in intellectual property laws from Queen Mary University of London. He is also an adjunct professor for intellectual property laws at his alma mater for the last 5 years. His teaching activity adds another dimension to his personality and keeps him abreast with the latest happenings in the field of intellectual property law. It is indeed an honor to have you with us in today's session, and we welcome you, sir. All queries related to the session shall be answered during the Q&A round at the end of the session. Participants may type their queries in the chat box. Now, I would like to hand over the session to Mr. Mathews Verghese and would request him to make his presentation on the topic today. Over to you, sir.
Right. Yeah. Thank you, Mona Lisa. I think, we've got all the technical problems out of the way. So, Mona Lisa, can you hear me?
Yes, sir, you are audible.
Wonderful. So, good evening to one and all, and welcome to the virtual school on IP, which is being conducted by FICCI, CPAM, and LearnLaw. The topic of today's subject matter or discussion is objections in examination reports or objections which are received in respect of registrability of marks. Often we have clients who come and ask, is it possible for us to register something or not? And the answers to most of them cannot be given in the first instance. The reason why it cannot be given in the first instance is because one needs to examine whether a mark is registrable or not under law in light of the sections under the Trademarks Act regarding to distinctiveness and the section which deals with the presence of a prior registration or an application before one can actively or objectively state that a mark is registrable or not. So today we're going to deal with the various types of objections and the various arguments that we put forth to overcome them as well. We will deal with these two sections of law in a little bit more detail as we go along. Mona Lisa, can you go to the next slide, please? Trademark. That's the subject matter of study today, the registrability of it and the objections that we often receive in respect of that. So what is a trademark? A trademark includes a word, a symbol, a logo, a phrase, or a combination thereof. It needs to be graphically represented. That is very, very pertinent in India. Unlike many other jurisdictions, graphical representation of a mark is much required. The case in point, the best example of it is in respect of sound, which was granted registrability as a trademark a couple of years ago. Used or proposed to be used. This is basically the recognition of the principle of the first to use, which system which India is a part of, rather than a first to file system like the United States, to identify and distinguish your goods and services from those of others. This is pertinent as a business owner. I do not wish to have any consumer confusion in the market. I don't wish to have a mark which is similar, identical, deceptively similar to mine, because one, it damages my reputation. There could be a loss of goodwill. There could be a lower quality good being sold. I don't want anyone remotely close to my mark existing on the register today. Let's go forward, Mona Lisa. A couple of examples of trademarks are what you see on your screen today. Malabar Gold is there. Netflix, which is commonly known for all of us, is a wonderful OTT provider and with good content. Mercedes-Benz for all the car lovers out there. McDonald's, one which resonates with everybody, and KFC as well. You have the Life Insurance Corporation, and you have Nestle as well. So these are a couple of trademarks which are existent as examples for you to understand what exactly they are and what is the subject matter of study. Now, each of these trademarks have gone through the process of law that we are going to enumerate in the coming slides. Melissa, let's go forward. Types of trademarks. There are a huge bunch of categories of trademarks that are there in the world today, which are recognized under the laws of each country. Words, letters, numbers, and colors. These were what initially started off as trademarks, anything which denoted origin. But over time, sound, shape, logos, packaging, all these as well came about. Logos, you could say, was always there, and the remaining sound, shape, and packaging. These are things which have recently come in to be regarded as trademarks due to the advancement of technology and manners and mechanisms in which the same is graphically represented as per our. It is quite interesting that this concept of graphical representation is very much inbuilt into our legal system. Anything which cannot be graphically represented, case in point, taste, cannot be regarded as a trademark. So there are jurisdictions which are dealing with smell and taste as trademarks, but it is not possible for us to do that in India. A good example of a smell mark is basically in respect of the European Union, where someone tried to register a tennis ball which smelled like grass. So as weird as that sounds, but that was exactly what was filed for. Let's move forward, Mona Lisa, please. The process of the trademark registration. It looks very simple. 1, 2, 3, 4, 5. It's 5 steps in all, right? To get something registered and renewed. But the time period taken for this is, in a straightforward case, without any examination or without any objections being raised during the examination stage, a 6 to 7 month time period. Go back 10 years ago, and you would find a lot of complaints by MNCs, a lot of complaints by foreign applicants, stating that India took a long time to register its trademarks under its trademark law legal system. It took close to 8 years, 10 years, maybe 15 years sometimes to get something registered. That used to be the lacuna, and that used to be the backlog which was there at one point of time. With digitization, the process has become much simpler, the process has become faster, and much more efficient, thus bringing down the time period taken to get a trademark registered. So today, the answer to the question, how long does it take to register a trademark, takes around 6 months or 6 to 7 months without any objections being raised in the process, as well as any oppositions being initiated by any third party. That's how much it takes. Our subject matter of study is the second box, examination. Once the mark is filed in the trademarks registry, the trademark registry examines the application which has been filed under 2 sections of law of the Trademarks Act 1999, namely Section 9 and Section 11. In the following slides, we will go over what entails objections under Section 9, what entails objections under Section 11. We will also go into how responses are created and drafted for these objections which are raised and the various submissions which are given. And we will just briefly touch upon case laws, not too much in detail, just a couple of them to give you an idea as to what we discussed as far as the theoretical aspects are concerned. Let's move forward, Mona Lisa. Before we go into Section 9, and that's going to be the first section that we're going to deal with, we need to understand what we broadly call as a spectrum of distinctiveness. Now, Section 9 of the Trademarks Act basically deals with, or rather stops marks which lack distinctiveness or are descriptive in nature to be registered as trademarks. Trademark is what we call a negative right, which basically means that by giving you a trademark, or rather stating that you are the owner of something, we basically say that we're giving you a monopoly right on that particular mark for, well, in respect of trademarks, it's in perpetuity, which needs to be renewed every 10 years. But it's basically a right which is in perpetuity. So we're giving you monopoly rights over something. When we give you monopoly rights, we have to also take into consideration that you are going to prevent others from using that trademark for reasons that we enumerated earlier. You don't want anyone having a similar mark or an identical mark existing in the market. One in business to existent there today. That's just plain business, theories and nothing more. So how does one choose a trademark? There are so many words out there, so many different logos out there. How does one choose one to overcome this objection which I just stated? The manner to look at it is basically on this spectrum that we're talking about. Generic words. Now, generic words are common words which identify the class of goods or services to which it has been applied for. Example, thermos for vacuum flask. A lot of us say thermos when we refer to vacuum flask, so hence it's become a word which is generic in nature. If today I was to grant, let's say I was to grant FICCI the right to the word thermos, FICCI would be able to prevent everybody else from using the word thermos today in existence. Thus, the word thermos could no longer be used by anyone except FICCI. So generic words are not exactly a great example of trademarks or trademark protection. The second type of words are descriptive in nature. Descriptive marks are, you can say, describing the product or the service which is being trademarked. So let's say Fair and Lovely for fairness creams, even though it is no longer being used by Hindustan Unilever, Fair and Lovely is a mark which describes the product for fairness creams, basically describes the product. Hence, it is a mark which can be stated to be descriptive in nature. A descriptive mark can be registered as a trademark, yes, but it is done through a manner where the mark acquires distinctiveness, having been used for numerous years, in such a manner that the consumer regards it as a trademark and is able to understand the origin of the mark to that particular company or that particular applicant. So descriptive marks are also on the lower end of the spectrum. Suggestive marks. Suggestive marks are registrable. It's a word that hints at an attribute of the good or service. Coppertone for suntan lotion. It takes me a while to figure out what copper tone would be used for. If I had just copper tone, I would be thinking of a whole host of products to which it can be used, and it would take me some time and some imagination to come to the conclusion that it is being used for suntan lotions. Thus, suggestive marks are registrable and the spectrum becomes stronger in respect of suggestive marks. Arbitrary marks are excellent, a common word used in an unrelated context. Camel for cigarettes is one. The most and the best example that I can possibly think of is Apple for phones and computers. Apple is a fruit. It's being used in an unrelated context to cover laptops, its phones, iPads, and a whole host of other things, technology related. No one could remotely even use or think of using a fruit for something like this. Hence, it's an arbitrary mark. Fanciful marks are wholly invented words. Kodak for cameras. You have something which may become generic in nature later on, is Xerox for photocopy machines. So Xerox is actually the trademark of the Xerox Corporation. They brought out the photocopy machines. What we regularly tell shop owners when we go and ask for a photostat is we tell them to Xerox it. That is a wrong usage of the word. And that is why you would see the Xerox advertisement stating, do not use our word as a noun or a verb. So by such usage, the word Xerox could become generic, thus go to the lower end of the spectrum, And Xerox Corporation does not want that. Hence, they are trying very hard to ensure that the trademark rights are protected and the distinctive character is not diluted. Let's move to the next slide, please. Yeah. From there, we go to the absolute grounds of refusal under Section 9. So Section 9 has various subclauses. So it's got 91A, 91B, 91C, and so on and so forth. We will deal in brief in respect of each of them, and then we will go on to how to respond to each of them as well. So Section 91A talks about something which is devoid of distinctive character. This means that the mark lacks the quality and the ability to distinguish goods of one person from those of another. So complete for soaps and cosmetics. It could be regarded as devoid of distinctive character. We're facing marks like Digital Summit for services for a summit on technology. Again, could trigger the section off. So these are marks which are not distinctive in nature. They're quite at the lower end of that spectrum which we just talked about. 91B deals with descriptive marks, the second portion of that spectrum that we talked about. It refers to the quality or nature of goods. Cold and creamy for ice creams is the one that comes to our mind. Cold and creamy, it doesn't take too much imagination to understand that it could relate to ice creams. Therefore, it's not a mark which is very high on the spectrum. Hence, it's descriptive in nature. 91C is customary in current language. The mark is common to use in trade. Escalator for moving stairs or a moving slide which goes upwards is not a good trademark. So you have to look at 91C in light of the goods and services which the mark is basically covering. Mona Lisa, could you go to the next slide, please? Yeah. The second set of objections that come about is under 9.2. 9.2 is basically of such nature that the mark is deceptive and may cause misrepresentation as to the characters of the goods or services. So if I say Swiss Tech for watches, it is slightly going to attract Section 9.2A. It may deceive the public because the public may think that the mark, rather the watch is made in Switzerland. Now, Switzerland is known for precision instrumentations or precision instruments. Watches made in Switzerland are regarded very, very highly, and they are priced as such. Hence, if someone was to use the mark Swiss Tech for watches, the consumer could get deceived that the mark actually originated from Switzerland. Maybe not. Maybe the watch has actually originated from China or somewhere in India. So Swiss Tech for watches is not a good trademark. 9.2B talks about marks which hurt the religious sentiments of other communities. This is something which is inbuilt into our constitution. We as a community, we as a country have laws which respect the religious beliefs of everyone. Hence, use of any religious names, symbols, pictures of any gods or goddesses and other religious figures or figurines are not regarded as trademarks. An example is Om for alcohol or meat products. This could attract Section 9.2B. Recently, we had a matter, or rather, we've dealt with matters for Khadi, wherein somebody has objected to the registration or proposed registration of Khadi for certain goods which he or she felt should not have been regarded to be registered for. So these are examples of marks which attract the religious sentiments or hurt the religious sentiments of people, and hence they are not regarded by law as trademarks or given registration for them. Section 9.2C contains matters which are scandalous or obscene in nature. So a mark which is offensive or causes outrage. Example, cocaine. So you can't register the word cocaine for just about anything. It's scandalous, hence it's not going to be allowed registration. And 9.2D talks about marks which are prevented under Names and Emblems Act. So we have something known as the Names and Emblems Act. It has a whole host of symbols, a whole host of logos which cannot be registered as trademarks. So you can't register the Ashok Chakra today. You can't register United Nations. So there are words, there are symbols, there are logos which cannot be registered under any law, especially the law of trademarks, and if applied for, would attract section 9(2)(d) and the objection under absolute grounds in respect of it. Yeah, Mona Lisa, next slide, please. Going forward, we have section 9(3). Now, 9(3) consists of marks which could be regarded as shapes as well. So a shape can be regarded as a trademark, but it has to be understood in the context of what it covers. So the shape of a banana for bananas, that's not going to be allowed, because the shape is an essential characteristic and is inherent to the generic function of that particular product. 9(3)(b) again talks about a mark in a shape where all the essential characters of the shape perform a technical function. So Lego bricks for construction toys. Another example of this, or rather another example which attracts 9(3)(a), 9(3)(b), and 9(3)(c), which says that a mark which gives a shape a substantial value cannot be registered, is the much acclaimed and much famous Rubik's Cube. So a Rubik's Cube has attracted, or the registration of a Rubik's Cube has attracted objections under section 9(3). Shapes are registrable in India. Shapes of bottles are the most common examples of shapes which are registered in India. It is not unheard of. It is not something which is not possible, but it may attract objections under section 9(3), and the right holder will then have to show that the mark is distinctive enough to obtain a registration. Yeah. Let's go forward, Mona Lisa, please. The second objection which comes about is what we term as relative grounds of refusal. They fall section 11 of the Trademarks Act. It's a very, very simple section. Think of yourself as a businessman. Think of yourself as a startup. Would you like to have a trademark, or which is identical or similar to yours existing on the market? You could have a whole bunch of problems such as loss of goodwill, loss of reputation, lower quality product, people complaining about a lower quality product which damages your reputation nevertheless. So you do not want anyone which is identical or similar to have a mark existing there in the market or on the trademarks register. And the law recognizes this. So a couple of examples are Sanofi and Sanofin with exact identical logos for goods which are medicinal and pharmaceutical preparations. Not going to be allowed. Yeah, Mona Lisa, to the next slide, please. Old Spice and Old Spice again for aftershave, and the other goods being for razors. So there is a variation in the goods here, but the mark remains the same. Even though the goods are different, there is consumer confusion which could occur. Similar with Gems and James. Here the trademark is different, but the goods are similar. So these are all various situations which the law predicts, or the law is thought about, and has subsections in respect of each. In each of these cases, what needs to be understood is, or what needs to be analyzed is there going to be consumer confusion? Because that is exactly what the trademark registry is also looking at. Consumer confusion is something which cannot occur, which does not have to happen. And if it does, then the trademark registry is not going to allow something to get registered as a trademark. Mona Lisa, could you go to the next slide, please? Mona Lisa, could you go to the next slide, please? Divyesh?
Just working on it. There seems to be some issues. Just working on it.
Yeah, sorry, I think we have some issues, technical, so just working. Yeah, I think we are back. And we have, so to the host, we've lost this slides. So could we just get the back, please? Yeah, thank you, Mona Lisa. So coming back, we were talking about section 11 and how we do not want any goods and services for whether they were similar or identical for marks which are identical or disciplinary similar to ours because it affects our business, right? So 11.2 also talks about something similar. It talks about whether registration of a mark which is identical or similar to well-known marks, even if the goods and services are not similar. So on your screen, you can see two trademarks, Adidas and Microsoft, really well known in their respective spectrums and respective fields. One for shoes, I've just taken shoes for now. Adidas uses a whole bunch of sports apparel, but just shoes for now. And you have Abibas, which deals with cushions and blankets. So what you can see here is basically that there is the logo which is used is deceptively similar. It's not identical. The mark is changed. So instead of Adidas, they have Abibos. And in respect of Microsoft, they have Microsoft, and unfortunately with the Apple logo. Microsoft is for computer programming services, whereas Microsoft deals with chemicals. So here the marks are different, the goods are different. There should not be any confusion, right? But they can be, because even though the goods are in different classes, the trademarks registry should not allow such marks to exist because they still can be consumer confusion. Today, the consumer may think that Adidas is also started manufacturing their line of cushions and blankets, and similar with Microsoft. So it could be a natural consumer who gets of average or imperfect recollection, who may not know any better, who may get confused. Hence, these kind of variations are also frowned upon and not allowed to registration. Yeah, Mona Lisa, to the next slide. Once we receive objections, and objections are received in what we term as an examination report. Rewind back to 10 years or 15 years ago, these examination reports used to come by post to the offices of the respective attorneys, and then we had to prepare a response in writing and then send it back by post to the trademarks registry, or go to the trademarks registry and submit it in person. Post digitization, what we have is a system which is much more fluid and much more efficient. We now receive an examination report via email. We also get SMS onto our phones, which says that this mark has been examined and the examination report has been issued. And then we can file a response. So we prepare a response and we file the response online through the online portal, which is there of the trademarks registry. Much more faster, much more fluid, and much more efficient. The entire system has changed because of digitization, and we're very happy about it. So once we receive the objections in the examination report, as an attorney, your job is to file a response depending on the objection which has been raised. The time period to file such response is 1 month from the date of the receipt of the examination report. Yes, we can seek an extension of time. The Act does not state how many extensions of time can be sought, but prudence must apply here. You can't seek an extension for 12 months. That's just misuse of the law. So ensure that you're well within common sense, you're well within, let's say, 2 to 3 months. Extension is fine, but don't keep seeking extensions for 12 months at end. That is just misuse of the law which is there. Extension of time is again for a 1 month time period. So every time your 1 month time period gets over, you need to file another request seeking an extension of time, which is worth 900 rupees. Filing a response to the examination report, there is no official fee associated or attached with it. So it's a very simple response to the objections which have been raised in a particular manner depending on where you're working and the style of writing which that firm or that entity has adopted. Let's move forward, Mona Lisa. So what do you put into the response that we just elucidated upon? We need to put in something, right? So it could be objections which are maybe lacking distinctiveness under section 9(1)(a), which we talked about. So our submissions are: A, the mark is inherently distinctive. It is an arbitrary mark. It could be coined or fanciful, which basically makes it an invented word. That means it's not even there in the English dictionary. Or it could have acquired distinctiveness through use. Now, this is quite interesting because you can only acquire distinctiveness if the trademark has been used prior to the date of application. You can't file your trademark application, subsequently use your trademark, and then put forth grounds of acquired distinctiveness. That is not right. That is not allowed. And it is theoretically wrong if an erroneous if one does that. At the time of filing your trademark application, you do have the option of claiming a date of use, which basically means that your rights predate all the way back to the date which you have claimed. So your application date will be much, or rather your use date will be much prior to your application date. So your rights predate from the date of use. Earlier, we could give any date of use and nobody was checking on it. There was no validation of the same. But what has happened is that in time, a lot of oppositions came about wherein the date of use was challenged. The applicants could not submit any evidence to validate that particular date. To ensure that this kind of misrepresentation does not occur, in 2017, when the amendments to the trademark rules were made, the Trademarks Registry also indicated and stated that if an applicant is claiming a date of use, he or she will have to validate that by way of an affidavit with use which needs to be there. So this was what came about. Hence, today, if I wish to claim a date of use, I have to show that it has been validated with evidence, which I have to submit by way of an affidavit. Let's go forward, Mona Lisa. Let's say an objection was raised under section 9(1)(b). In this kind of a scenario, the submissions or our arguments have to be based on these 3 or 4 suppositions of law, which we need to back with cogent evidence or case laws. One is that we view the mark as a whole, and we need to look at it in respect of the services for which it has been applied for. It cannot be dissected away from it. 2, it's an arbitrary trademark, straight off. It's unfamiliar, has no connection to the goods and services, and hence it needs to be protected. 3, it's suggestive in nature. Now, a mark may not be arbitrary all the time. It might be suggestive. It might suggest to the consumer what the mark is being used in respect of. In those kind of cases, we could put forth arguments that the mark is suggestive in nature and prove to the Trademark Registry that the mark needs to be registered nevertheless. Or it has acquired distinctiveness, something we just dealt with slightly earlier in the prior slide. So these are the 4 main arguments one can put forth if one received an objection under section 9(1)(b). Mona Lisa, could you go to the next slide, please? Coming to case laws, which we have in respect to section 9(1)(a). Now, we have a whole multitude of them, but I've just taken a few ones which are pretty interesting, you could say. So the word superflame. So the word superflame was dealt with in Globe Superpass versus Blue Superflame Industries and others. The question was whether superflame was distinctive in nature, whether it was fancy or coined. And it was regarded that it was. So superflame for the goods and services which it was covering was not a common word in the English language and did not have any meaning. Hence, it was arbitrary in nature, it was coined, it was fancy. The second one was Playboy Enterprises versus Bharat Malik. The portion which is interesting here is that one with respect to paragraph 39, it says the trademarks are mainly of 4 varieties. It may be arbitrary, fanciful, and does not give any connection to the nature or type of goods. So if a mark was there and it did not have any connection to the goods and services which it was striving to cover, then the mark should be regarded as distinctive in nature and allow registration. So that's what that basic judgment basically talked about. Could we move forward on Lisa, please? Yeah, we have further case laws in such like Telecare Network and ASUS technology, wherein a common word is applied in an unfamiliar way, and that was known as a arbitrary trademark. Ivory would be generic when used to describe a product made from the tusk of elephants, but would be arbitrary when applied to soap. So if I use ivory in respect of soap, that's fine. Ivory in respect of products made of elephant tusks, maybe not so. Okay, I could put forth arguments that it was suggestive, but then it would remain to the registrar to decide whether it was suggestive or whether it was not. Again, in the case of Aegon Life Insurance versus Aviva Life Insurance, what was basically stated was whether words or marks claimed as trademarks are descriptive or whether they are suggestive or arbitrary or fanciful must be decided with respect to the articles of which they are applied, and the mark must be considered as a whole. So it seems that the goods and services covered by the mark play an important role in deciding which end of the spectrum of distinctiveness the mark falls in. Let's move forward, please. Mona Lisa, could you go to the next slide, please? Yeah, you could go to the next one, that's fine. Mona Lisa, could you turn over to the next slide? Yeah, thank you. So those are case laws in respect of section 9 and the objections and the absolute grounds. But what about section 11? The biggest usage of an argument is that one which is of entirety. We call it the principle of entirety. It basically is a very simple deal. The earmark or landmark case law in respect of that is Corn Products versus Shangri-La. It basically states one very simple thing. Let's say I had a mark which had two elements in it. I can't split one element or one word and say it's similar to another mark. All the marks which are cited against me in the examination report may have just that one element which is similar. But on the basis of that, I can't say that the marks are identical or deceptively similar, and I can't not be granted registration. What needs to be looked at is, when put together with all the various elements, is my mark similar or identical to the numerous other marks on the register which are existing? It's a very, very simple principle, but it is used quite a lot. The reason is very simple. The Trademarks Registry does raise quite a lot of objections in respect of section 11. There are some times when we find a lot of these objections to be erroneous. They do not make any sense, but they have been raised because the manner of examination needs a lot of improvement, which the Trademark Registry is working on a day-to-day basis. Hence, this is a portion which, this is a argument which is very, very commonly used. And this case law is something that you would find across firms, across languages, and every trademark registrar understands this basic principle. The second principle that we have to overcome objections under section 11 is prior use of the mark. If I have been using the mark much prior to a person who maybe filed an application, has no user, but filed an application on an intent to use basis or a proposed to be used basis, I should be given rights. I stated earlier that India is a first to use country and not a first to file country. Therefore, if I am the prior user and adopter in the market, I should definitely have rights in my mark, even though I filed subsequently. So this is another principle which the Trademark Registry looks at, and another argument or point of argument that one needs to make when tackling objections under section 11 of the Trademarks Act 1999. Mona Lisa, could you move forward, please? Differences in goods and trade channels. So recently there was this very, very good judgment which we can use whichever way we wish to, called Nandini Deluxe versus Karnataka Cooperative Milk Producers Federation Limited. Now, as per this, it was stated that if there were a whole bunch of goods in a particular class, both my mark and the mark which has been cited against me are also in the same class, but the goods are different, then the marks should be allowed to coexist and should be allowed registration. The judgment, personally, is a little bit flawed because it does not take into consideration that the goods mentioned in the same class or the services mentioned in the same class could be cognate or allied to each other and would therefore result in consumer confusion. Unfortunately, or fortunately for us, this is a Supreme Court judgment, hence is still standing. Though the Trademark Registry hates it, we regularly use this judgment to our benefit when arguing matters before them, because it helps us overcome quite a lot of objections, and it's quite useful. On the merits of it, the judgment is flawed, but is it useful to us? Yes, very much so. But differences in goods and services and trade channels is an argument that one can put forth to ensure that a consumer is not confused. If I am dealing in, let's say, clothing, footwear, and headgear, there is very remote chance that a consumer will get confused with goods bearing a similar trademark for pharmaceuticals. I, as a consumer, know what I'm going to purchase today, whether it be a shirt, whether it be a shoe. I know what I'm going to purchase. I'm definitely not going to purchase paracetamol tablets thinking that they're going to be shoes. That's not going to happen. And I don't think that's even a remote possibility. Hence, the argument that the goods and services are vastly dissimilar is one which can hold ground. The last one is obviously invalidity of marks which are cited in the examination report. Much prior to the digitization that we see nowadays with the Trademarks Registry, there was a time when everything was by hard copy and it was by files. When the digitization occurred, a lot of the data which was put up on the Trademarks Register was slightly erroneous in respect of the status. So you may often come across marks which are abandoned or removed, they are refused or withdrawn, and the order is updated and uploaded, but you may not find the status of the mark to have changed. Hence, when examining a trademark or examining an examination report and the marks which have been cited, it might be useful for one to also look into the particulars and the documents which have been uploaded of the marks which have been cited to ensure that no such order which invalidates that particular mark is there. 7 times out of 10, you might find a document which helps your case and you can put it forward, thus ensuring that your arguments are short and crisp, and also ensuring that the cited or the objection which has been put forth is moot. Let's go forward, Lisa. Yeah. In conclusion, Section 9 and 11 are very much a part of trademark attorneys' bread and butter, I could say. The understanding of it takes time, and so does the arguments which one needs to put forth. The best way to learn these arguments is to read up on case laws which enumerate and elucidate the points in respect of it and understand the principles which govern them. Understanding the objections also helps one as an attorney to ensure that one is able to give good advice to the client at the initial stages. When we do a trademark search, we search for objections, or rather we look at it from the point of objections which could be raised under this particular sections of law, which are there, namely absolute grounds and relative grounds. It is on the basis of our understanding of these two sections that we are able to give a more comprehensive search report and thus enable our client to ensure that he's able to get a mark which is registrable. So the understanding of these two sections of law are quite important and pertinent, and the subject matter of study therefore is quite vast, I might add, but we have tried to just bring it down into our particular time that we have today with us. So over to you, Mona Lisa and Divesh, for further questions.
Thank you so much for such an insightful session, sir. I now proceed to Q&A session. If anyone from the audience has any question, please type the same in the chat box and we will put the same to the speaker. Sir, there is a question from a participant. How
Sure.
important it is to conduct a private search to avoid an examination report?
Very important. Look at it. Okay, let's say one of you or each of us were purchasing a car or even smaller, a phone. If you look at your own self, you would see 10 YouTube videos before you purchase that phone, read a dozen reviews before you commit that money to purchase that phone. It is very similar to that. As a business owner, before you put in money, before you invest money and get something registered, you need to understand whether is it even possible to get something registered in the first place. Hence, doing a trademark search enables you to understand that. It may not be possible in certain cases to get something registered, and hence you should not go with it. The reason being that once you put in money, once you invest money in advertising, you invest money in packaging, you invest money in promotions, paid promotions sometimes through social media posts. Once you do all that, you don't want to be in a situation where, let's say 10 months down the line, you face an opposition from another party and you eventually lose the trademark and you're told that you can't get that particular trademark registered to you. In that kind of a scenario, all the money that you've spent, which I just touched upon earlier, is lost. You're back to square one and you have to start over again, creating a new brand along with the reputation, the goodwill, which you need to now recreate for that particular brand. So doing a trademark search is very, very important, very pertinent, and the money spent doing it is, I would say, an investment well spent.
Yes, sir. Do we have any more questions? Sir, there is a question from Sumit Pandey, a participant of ours.
Sure.
Yes, sir. Why do we need to verify details of applicant who files marks similar to our client? I've come across many assignments where client had asked us to investigate applicant's background. Does it help in filing objection?
Your investigation may be pertinent in respect of an opposition. It does not, and additionally, you may also want to investigate to understand whether, in certain case, whether the mark is purchasable from that particular person. In answer to whether it can help you overcome objections, no. You could maybe understand the scope of his business, maybe understand the trade channels to put forth arguments on the grounds of difference in goods or services. But that's as much as an investigation would help you to overcome objections on 9 or 11, section 9 or 11. An investigation may be more pertinent if you are filing a rectification action on the grounds of non-use to cancel a particular registration which is already there, or if you are looking to take action such as an opposition action against that particular party.
Absolutely, sir.
Answered that question. If you have a second question to that, you can just type it in and I can get you that. Sumit, one more thing to add. I just saw your question which has just been put up. Sometimes clients also want to know whether they are in a competing business, whether the mark which has been cited is in a competing business or not. For commercial and business sense, sometimes it's also good to understand whether they are in competing businesses, because if they are, then you're looking at a problematic situation off the bat. So that's another point which I just thought of when I saw your question right now in the chat box.
Sir, the next question from a participant is, are foreign judgments acceptable by the trademark registry in the reply compared to Indian judgments when the Indian judgment on a particular aspect is not available?
A foreign judgment has the same effect that it has on courts, persuasive nature. It is not binding on the trademarks registry. It is not binding on them. It is persuasive in nature and hence can be cited, can be used. Nothing stops you from it. But the enforcement or the binding nature of that foreign judgment is not much. It's more of a persuasive nature and can act as a guide to help the trademark registry make their decision where there is a lacunae in the law which is currently there at our disposal.
Thank you so much for addressing the question, sir. It was wonderful having you in today's session. Thank you, sir.
Thank you, Mona Lisa. Have a good evening. Have a good evening all. Thank you.
Thank you, sir. Thank you, everyone, for being a part of our sessions of the Virtual School on IP. We now conclude this session.